A huge number of people will never discover this until the window has already closed on them. Not because the facts are tucked away in secret, not because the subject is beyond understanding, but because the type of shifts that quietly redefine millions of futures almost never gain traction on social media or dominate the evening news cycle. They unfold within judicial chambers, articulated in statutory language that the average person never takes time to review. And by the moment the typical American senses that something fundamental has moved, the economic repercussions are already taking hold. That is precisely what has just happened. The Supreme Court of the United States has handed down a unanimous 9-0 opinion. Each and every justice, from the furthest right wing to the furthest left wing, arrived at the identical judgment, and what they concluded has irrevocably transformed how retirement functions across this entire country. Not on a temporary basis, not restricted to one jurisdiction, not limited to a narrow population, but irrevocably and throughout every corner of the nation. If you maintain a pension, direct funds into a 401k, draw Social Security, or have ever crafted financial blueprints assuming retirement provisions would remain unchanged when you eventually needed them, this opinion directly touches you. The reason this demands such immediate attention right now, before mainstream reporting fully catches up, is that the protection it creates does not mechanically insert itself into your personal situation. You must internalize it first. A Supreme Court opinion is only advantageous to those who learn how to leverage it. So let us unpack what genuinely transpired, why 9 justices who almost never reach consensus arrived at unified agreement here, and why legal professionals are already labeling this among the most transformative retirement opinions across the last 50 years. Before getting there, you must appreciate what was authentically on the line, because this case did not launch as a defining chapter. It commenced with one solitary person declining to accept that the government could alter the conditions after the match had already been concluded. Picture investing 30 years of your life anchored to particular guarantees, not offhand guarantees, but ones carrying legal weight. Guarantees encoded into official policy, woven into the retirement architecture you supported with each and every paycheck year after year. You crafted life decisions anchored to those pledges. You pursued a career in civic employment because the pension structure made it sensible. You continued living in a state you could have otherwise abandoned because its retirement taxation model reinforced your financial trajectory. You mapped out your savings, your departure from the workforce, your investment approach, all erected upon an architecture the government itself constructed and motivated you to place confidence in. Then one afternoon, without requesting your feedback, without gaining your agreement, and without factoring in the decades of groundwork you had already laid down, the government revised the conditions. Not solely for prospective enrollees, but reaching backward to individuals already thoroughly entrenched in the architecture, individuals who in practical terms had zero possibility of launching over. That is what befell the retiree positioned at the nucleus of this dispute, and that is what the Supreme Court was summoned to examine. The question was not whether governments can refresh legislation. They unquestionably can. It was not whether retirement architectures can undergo restructuring. They absolutely can. The genuine question was substantially more focused and immensely more powerful. Can a government reshape retirement provisions in a manner that directly injures individuals who arranged their total financial reality around the preceding architecture? The unanimous declaration from every single one of 9 justices was no. Not unless the government clears a remarkably demanding constitutional benchmark. Not unless it can establish the revision is defensible enough to override decades of authentic life groundwork assembled upon the prior legislation. To fully grasp why this holds such immense importance, you need to internalize the foundational legal concept sitting at the nucleus of the dispute. the justices zeroed in on a principle recognized as reliance. It is a legal expression, but the core thought is elementary. When you undertake consequential life decisions rooted in a prevailing regulation, when you commit years and finances into an architecture because of the way it operates, you are counting on that architecture. And when the government fashions an architecture deliberately engineered to guide long-range conduct, fostering saving and strategizing decades into the distance, it cannot afterwards strip away that bedrock without facing accountability. That is what reliance represents. And what the Supreme Court has now affirmed with complete unanimity is that retirement strategizing stands as one of the most powerful demonstrations of reliance within American legal tradition. Retirement is not a fleeting determination. It is not something individuals smoothly reconfigure every couple of years. It is an entire lifetime pledge erected upon the conviction that provisions will persist steadily enough for the blueprint to deliver results. Ahead of this opinion, states wielded sweeping power to reshape retirement-connected legislation. They could recalculate pension structures, levy additional taxes upon retirement revenue, or push upward the qualifying age for complete benefits. They routinely rationalize these steps by insisting that governments demand flexibility to administer finances and answer shifting economic landscapes. On the surface, that logic holds together, but it neglected something indispensable: the flesh and blood human beings bearing the weight of those revisions. The instructor who poured decades into a schoolroom because the pension transformed a humble salary into something sustainable. The firefighter who endured inside an exhausting occupation because retirement compensation rendered it economically workable. The retiree who transplanted across the entire country chasing tax relief only to watch that relief evaporate not long afterward. These are not imagined circumstances. These are authentic human lives. What the Supreme Court has now articulated is that those determinations, those years of groundwork, and that counting on government-constructed architectures warrant constitutional defense. This is the precise moment where the opinion turns authentically transformational. The court did not simply announce that reliance possesses importance. It engineered a three-component constitutional evaluation that states are now obligated to pass before reshaping retirement legislation in manners that disadvantage individuals who counted on them. Even more significantly, the court reassigned the burden of proof. In earlier times, retirees carried the duty to show that a policy revision was inequitable, frequently necessitating legal assets they plainly did not have access to. The state retained the dominant position. Now, the entire arrangement is flipped. The presumption launches in support of the person. The state is required to prove that its revisions are defensible, notwithstanding the counting on that citizens invested in the prior provisions. This reassignment is not insignificant. In legal confrontations, whichever side bears the burden of proof commonly controls the final determination. By directing that responsibility onto the government, the court has structurally redrawn the distribution of power. For the very first occasion, retirement determinations undertaken by millions of Americans are being treated as constitutionally defended reliance. That said, it is necessary to maintain a realistic perspective. This opinion does not eternally freeze retirement legislation into its current form. States preserve the capacity to enact revisions. What has evolved is the standard they are compelled to reach. The bar is now markedly more demanding. This is not a blanket assurance. It is a defensive barrier. And identical to every defensive barrier, it exclusively advantages those who internalize it. In the upcoming segment, we zero in on who profits the greatest. Public sector employees constitute the initial category directly touched. Instructors, police personnel, firefighters, medical professionals, and civil servants spanning the entire country. These people regularly settled for diminished pay in exchange for reliable retirement arrangements. When those arrangements were afterward cut back, it generated profound hardships. This opinion now equips them with more robust legal standing to oppose such revisions. The second category covers retirees who transplanted themselves guided by state taxation frameworks. A great many individuals shift locations during retirement to lower taxes on revenue such as pensions or Social Security. When states afterward overhaul those frameworks, it can meaningfully disrupt their economic position. Pursuant to this opinion, such determinations may now fall under defended reliance. The third category encompasses employed Americans still building their retirement reserves. Those channeling money into 401ks or IRAs anchored to existing provisions are equally covered. Retirement strategizing is a perpetual undertaking, and each individual contribution embodies reliance upon the architecture functioning at that specific point. The three-component evaluation determines the manner in which the defense operates. First, did you undertake monetary determinations anchored to prevailing provisions? Second, would the revision produce authentic harm? Third, can the government substantiate that harm with a sufficiently powerful justification? Only when each and every requirement is fulfilled can revisions advance. So what actions should you pursue immediately? Commence cataloging everything. Maintain records of taxation frameworks, pension particulars, and account documentation. These could emerge as indispensable proof. Meet with a financial specialist who fully grasps these shifts. Scrutinize your retirement blueprints with great care. For public sector employees, measure your pension arrangements against any newly introduced revisions. This opinion spotlights a more fundamental truth. Retirement security has eternally hinged upon trust, assurance that architectures will continue to be steady. For years upon years, that assurance possessed no authentic enforcement power. This ruling reshapes that equation. It announces that reliance is not merely a wish, but a constitutional stake. The chapter is only in its opening pages. States will answer in divergent manners. Additional legal clashes will chart the perimeters of this opinion. But one conclusion is indisputable. The age of discreetly revising retirement provisions without facing consequences has reached its end. What you elect to do at this juncture carries real significance. Those who internalize and respond to this will stand in a stronger position. Awareness here is not simply leverage, it is armor. Forward this to anyone mapping out their retirement because economic realities refuse to wait around for consciousness. The Supreme Court has rendered its position with complete unanimity. The signal is unmistakable. Retirement provisions can no longer be revised without facing accountability. This is a long-anticipated revolution, and it rightfully belongs to every American who mapped out, preserved, and entrusted their future to the architecture to